All right, let's just jump right into it. We're all surrounded by laws, right? From simple traffic rules to huge constitutional rights. But have you ever stopped and asked yourself a really basic question? What is it that actually makes a law a law? I mean, what if a rule gets passed, but it's just monstrously unfair? Is it still a law that we have to follow? That's the huge question we're going to be tackling today. It sounds totally contradictory, doesn't it? How can a law itself be illegal? But this isn't just some abstract philosophical puzzle. It's a real-world question that was put to the ultimate test in the aftermath of one of history's darkest moments. So picture this. It's Nazi Germany. A woman wants to get rid of her husband. She reports him to the authorities for making insulting remarks about Hitler, which, under a Nazi statute, was a crime. He was actually sentenced to death, though he ended up being sent to the front and, amazingly, survived. Now, fast forward. The war is over, and she's on trial. And her defense? It's pretty simple. Hey, I was just following the law that was on the books at the time. So, the court had to answer this massive question. Was that Nazi statute she used a real law, or was it something else entirely, just masquerading as a law? To even begin to answer that, we've got to look at the two heavyweights of legal philosophy who've been battling it out for centuries. This is really the ultimate showdown between how we think law works and how we think it should work. Okay, so in one corner, you've got legal positivism. The positivists, thinkers like Hart, they argue that a law is a law if it's made through the proper process. Whether it's a good law or a bad law, a moral one or an evil one is a totally separate issue. An evil law is still a law. But in the other corner, you have natural law theory, and they say, not so fast. For them, led by folks like Lon Fuller, a rule has to pass some kind of basic moral test to even be considered a law. An incredibly immoral rule, they'd say, isn't just a bad law, it fails to be a law at all. So let's dig into Lon Fuller's side of this, because his idea is really fascinating. He didn't just say, laws must be good. He came up with something way more specific. He argued that the whole process of making and running a legal system has its own kind of built-in morality. And this right here is the heart of his argument. Fuller believed that if a system of rules completely ignores certain basic principles of fairness and logic, it literally stops being a legal system. It just becomes brute force wearing a costume of legal language. So, what are these magic principles he's talking about? Well, Fuller lays out 8 of them. Think of it like a quality control checklist for any legal system. First, laws have to be general, not just targeting one person. They got to be public. You can't have secret laws. They need to apply to the future, not punish you for something you did yesterday when it was legal. And of course, they have to be clear, consistent, possible to obey, and, not change every 5 minutes. And the big one at the end, the government itself has to play by its own rules. If a system fails horribly at these things, Fuller says you don't just have a bad legal system, you have no legal system whatsoever. And all of this sets the stage for the main event, the legendary debate between Hart, the positivist, and Lon Fuller, the natural law guy, published back in 1958. This is where they went head-to-head, directly clashing over the problem of those Nazi laws and that grudge informer case. So Hart comes back swinging. He basically says, look, as awful as those Nazi laws were, they were treated as law by the officials and the society at that time. So legally speaking, they were valid. To pretend they weren't law, for Hart, is to just confuse the issue. He says it hides the really terrible moral choice the post-war courts had to make. Either you let the informer go free, or you admit that you're creating a new law after the fact to punish her, just this once, for the sake of justice. Hart's big fear was that mixing up law and morality just leads to fuzzy thinking. So let's just break this down nice and simple. For Hart, a law's existence is a social fact. For Fuller, it's got to meet a moral standard. For Hart, whether a law is valid is a separate question from whether it's moral. For Fuller, those two things are deeply connected. And that leads to completely different takes on the Nazi laws. Hart says, they were valid laws, but they were wicked. Fuller says, nope, they were so fundamentally broken that they weren't valid laws at all. Now, as you can probably tell, this whole debate gets super complicated really fast. We throw around words like right all the time, but in a legal sense, it can mean a bunch of different things. To actually get to the bottom of these arguments, legal thinkers realized they needed a much more precise language. And that's where this American scholar named Wesley Hofeld comes in, with this absolutely brilliant toolkit for clearing up the confusion. Hofeld's big idea is something he called jural correlatives. It's a simple concept, but it's incredibly powerful. Basically, no legal right or position exists all by itself in a vacuum. It's like a seesaw. If I have a right to something on my side of the seesaw, it means someone else has to have a corresponding something on their side. You just can't have one without the other. So Hoffeld's broke down all legal relationships into these 4 pairs. If you have a right, then someone else has a duty to you. If you have a privilege to do something, say walk in a public park, then that means everybody else has no right to stop you. If you have the power to do something, like a boss having the power to hire someone, then the applicant has a liability to that power. Their legal situation can be changed by it. And finally, if you have immunity, like a diplomat who can't be sued, then other people have a disability. They lack the ability to sue you. Let's make this super concrete. A tenant's right to live in their apartment isn't some vague idea. It directly creates the landlord's duty not to just kick them out for no reason. See? They're 2 sides of the same coin. Or think about this. A government's power to create a new law also creates the citizen's liability to that law, meaning their legal status is now subject to that new rule. Getting this kind of precision is just absolutely critical if you want to write laws that actually work. Okay, so we've got a dramatic court case from post-war Germany, 2 philosophers duking it out, and a complicated-looking table of legal terms. You might be wondering, why does any of this stuff still matter today? Well, because this debate isn't just some dusty old historical argument. It is the living, breathing foundation of how we think about justice and the rule of law right now, today. Think about it. Lon Fuller's 8 principles, that's basically the DNA of what we now call due process and the rule of law. Those crucial ideas that protect us from governments just doing whatever they want. HLA Hart's sharp distinction between law and morality, it continues to shape how lawyers and judges think, forcing us to be really clear about what we're arguing. And Hoffeld's toolkit, it's used literally every single day to write contracts and laws that are as clear and loophole-free as possible. And that brings us right back to Fuller's incredibly powerful point. He forces us to think about a breaking point, a point where a system of rules becomes so corrupt, so arbitrary, so broken, that it loses the right to even be called law. Which, of course, leaves us with the ultimate question, one that every society, every generation really, has to figure out for itself. It's one thing to say a law is bad, but where exactly do we draw that line? The line where a bad law becomes so fundamentally broken that it crosses over into being no law at all. Now that is something to think about.